Hello, my name is Frank. I'm a solicitor in the Exceptional and Complex Cases team. In this session, I'll be focusing on controlled work in the context of immigration. Please note that the slide contents mostly serve as background information. I won't be covering all the details on them. Instead, I'll focus on the key points as I go along. Now, by the end of this session, you will have an understanding of the basis for applying for controlled work under ECF immigration, knowledge of the tests that needs to be satisfied for those applications, practical advice for applying for controlled work under ECF immigration, guidance on how to challenge ECF decisions and manage urgent applications. Now I'm just going to move on to the next slide. The Exceptional Case Funding Scheme was introduced in April 2013. It is designed to provide legal aid in situations where a case falls outside the normal scope of legal aid. So it is really very important to know what is in scope and what is out of scope. For you to determine what is out of scope, you need to know what is in scope of funding. And we have to look at Schedule 1, Part 1 of the Legal Aid Sentencing and Punishing Act 2012, which I will refer to as LASPO. Under Schedule 1, it outlines the type of civil legal services that are eligible for in-scope legal aid funding. The schedule is divided into categories, each specifying cases types and where legal aid can be provided. So if a matter is not listed in Schedule 1, Part 1, it is generally considered out of scope. In such cases, you may need to apply for exceptional case funding. Now, why is this important? Knowing Schedule 1, Part 1 basically allows you to know that if a matter is in scope, you do not need to put in an application for ECF. So before applying for exceptional case funding, always check whether the matter is already in scope. Examples of in-scope matter include victim of trafficking in certain circumstances. So we are going to be looking at paragraph 32A, Schedule 1, Part 1. It will tell you that, this matter is in scope of funding and you don't need to apply for exceptional case funding. Another example has to do with separated children who have specific provisions which apply, and this is paragraph 31A, Schedule 1, Part 1 of LASPO. So in a nutshell, it is very important to always familiarize yourself with Schedule 1, Part 1 of LASPO. Now, one other thing that usually will happen is that it's also common for us to receive applications that include both in-scope and out-of-scope issues. In such cases, the exceptional case funding team will only deal with the out-of-scope elements. We do not have authority, that's the ECF team, do not have authority to deal with in-scope matter. Now, when we receive those information, when we receive applications that are mixed, that's in scope and out of scope, the CW2 form, you can use the same CW2 form you have used for the in-scope matter for the ECF matter. If the Article 8K issue arose at the same time as the in-scope matter, we will grant funding from the date the controlled work forms were signed. If the Article 8 issue arose later, ECF will be backdated from the date ECF form was signed. Now, for all this, I'll refer you to the ECF providers pack. Now, let's now move on to look at legal help specifically in the context of controlled work. Under legal help, to qualify for funding, an individual must meet two key requirements. They need an exceptional case determination and must also satisfy the means and merits test. In respect of means, the same regulation apply as outlined in the civil legal aid. I won't go into details on the means test today as my colleague Graham will be covering that topic shortly. What I'm going to be concentrating on is going to be the merits criteria and the ECF criteria. So under the merits criteria regulation 32, the test applied is the sufficient benefit test. The guidance on the reasonable private paying individual test outlined in the Lord Chancellor's guidance plays a key role in interpreting this test. The test is applied objectively. It is based on a reasonable person. Someone using their own money will be in terms of when they are making, if they decide they are going to be pursuing a claim. And the reasonable the reasonable private paying individual test is properly explained in the Lord Chancellor's guidance. So I'm not going to be saying much about that. But I'm just going to say a few things when you are submitting an application for legal help to the ECF team. It is important to consider several factors under the sufficient benefits test. This isn't an exhaustive test, but here are a few key points to keep in mind. Is legal advice required for the matter at hand? Does the cost-benefit analysis support the case? That is, do the potential benefit justify the cost? And finally, does the applicant have access to alternate source of funding that it will be reasonable to expect them to use instead? These are the kinds of questions we are looking at when we are assessing whether the test is met. Let's now look at legal help in the context of family reunion cases under ECF. The reason I'm dealing with this is because we get a lot of applications on this. For legal help in family reunion cases, where the means and merits tests are satisfied, the sponsor, that's the person in the UK, can apply for legal advice in relation to the family reunion application. The ECF1 form and the CW1 form should be in the sponsor's name. When submitting an application on behalf of multiple applicants in a family reunion case, particularly where the sponsor is applying on behalf of the family members abroad, please consider the following. If the facts and the legal issues are the same or closely connected, but you determine that separate representation is required, it is good practice to provide us a brief explanation why separate representation is necessary. This is important because the legal aid agency has a duty to assess and consider the justification for separate representation. This is even more important because under the Lord Chancellor's guidance, exceptional funding guidance, non-inquest, we're looking specifically at paragraph 35 to 38, the legal aid agency must ensure that only the minimum level of service necessary to meet its obligation under the ECHR or EU retained rights is provided. What does this mean? It basically means that, for example, if a single ECF grant can resolve the legal issues for all applicants, then funding will be granted for one individual applicant only. Therefore, if we are requesting separate representation, it is essential to provide a clear justification for why it is required. I'm now going to move on to the next slide, and we're going to be exploring the exceptional case funding criteria for under legal help. Now, the criteria for exceptional case funding are set out clearly in section 10.2.3 of LASPO. What basically this means is that even if an applicant meets the means and merits test, they must still satisfy the ECF criteria. In essence, the only time we make an exceptional case determination is when refusing legal aid will result in a breach or a risk of breach of the individual's right under ECHR or EU retained right. Now, the Lord Chancellor's guidance under section 4.3 section 4.3 of LASPO provides a framework on how this application should be assessed. So basically, for you to be, when you are looking at the overreaching question, you need to assess it through the lens of section 4 of LASPO. So some of the key factors we consider are going to be: one, how important are the issues at stake? For example, what are the consequences for the applicant if they don't submit the application or can't challenge the Home Office decision at the First Right Tribunal? How complex is the case? So we are looking at legal complexity, procedural complexity, and factual complexity. How capable is the applicant of presenting their case effectively? We look at things like emotional involvement. Will that affect their ability to present their case? Language barriers, caring responsibilities, and any disabilities that may affect the ability to engage with the process. just quickly need to make this point that all these factors are all indicators, not tick boxes. So the overreaching question, just a quick summarization of this, because I'm going to be dealing with this again under CLRO. The overreaching question we're trying to answer is, will denying legal aid prevent the individual from presenting their case effectively? And will that lead to clear unfairness? Now, to be able to answer the overreaching question, we are going to weigh all the factors under 4.3. So we're looking at importance, complexity, capability, and we do it on a case-by-case basis. No single factor is decisive. It is about the overall picture and the strength of the representation made on behalf of the client. Now, I'm just going to move on to the next slide, and that's going to be dealing with control legal representation in respect of appeals before the first tribunal. Now, as with legal help, individuals applying for control legal representation must meet two key requirements, as ECF determination, and they must also satisfy the means and merits test. However, it is important to know that the merits criteria for control legal representation are different and are set out under Regulation 60. In terms of the means, it's exactly what I've said for legal help. Now, just before I go into the merits criteria, I want to highlight a few important points. And the points I want to highlight are, the first point is that an applicant who is applying for ECF must be the appellant from abroad. So I'm just going to repeat that again. The first point is that the applicant who is applying for ECF must be the applicant from abroad. So if you have a first tribunal hearing, and in a family reunion case, it will be the person abroad who's appealing the entry clearance officer's decision. So the sponsor is not a party to the proceedings and therefore cannot apply for control legal representation. This is clearly set out in Regulation 18 of the Merits Criteria Regulation. So when applying for control legal representation, the ECF1 form, the CW2 form must be in the name of the appellant. The means assessment is based on the appellant's financial situation, not the sponsor. However, we need to remember that under Regulation 39, the legal aid agency may consider whether there are other sources of funding, such as a sponsor. So it's very possible that the sponsor's means in certain circumstances may be taken into account when looking at the means test. Now, there's one exception to the rule, that the applicant who is applying for funding must be the appellant. This is where the sponsor is a separated migrant child. In that case, the child sponsor can apply for controlled legal representation in their own name. This is permitted under Regulation 18, and more importantly, this is in scope of funding, so exceptional case funding is not required. Let's now turn to the merits criteria. And as I said, as you can see from the slides, Regulation 60 deals with the process of success. This is an objective test. I'm just quickly going to run through some of the levels of prospect. To satisfy this test, the director must be satisfied that the case has one of the following levels of prospect: very good, good or moderate, borderline, marginal, unclear. Now, it is good practice to familiarize yourself with these categories, because when you submit an application, you will need to tell us which category you believe the case falls into and why. Also, under Regulation 39, Regulation 39 must be read in conjunction with Regulation 39. Regulation 60 must be read in conjunction with Regulation 39 of the merits criteria. That is, an individual may only qualify for legal representation if the director is satisfied that the criteria in Regulation 39A to E are met. So just a quick recap on that. So even though we have the merits test for talking about the classification under Regulation 60, So even if an applicant meets those regulations, they still need to satisfy Regulation 39. And the most frequent regulations we use are regulations that applies to ECF immigration, are Regulation 39A and 39A. Now, under Regulation 39A, we must consider whether the applicant has access to other potential sources of funding, such as a sponsor who will reasonably be expected to pay for the appeal. Under Regulation 39E, which I will deal with more, we assess whether there's need for representation. This is particularly relevant in cases involving multiple appellants whose appeal are linked at the first trial tribunal. So, if you are submitting multiple applications based on the same facts or legal issues, and yet the appeals are linked at the first trial tribunal, but you are requesting separate representation for each applicant, it's again good practice to explain why. As I've just previously said, under the Lord Chancellor's guidance, we're under a duty to consider this. Now, I'm just going to move on to the next slide. Now, I won't repeat the ECF criteria in details. I've already covered them in the context of legal help. The criteria remains exactly the same here. So, as I've said before, the legal basis is set out in 10.2 and 3. So even if the applicant meets the means and merits criteria, they must still satisfy the ECF threshold. It is exactly the same for control legal representation. So just a quick recap. As mentioned earlier, the key question is whether refusing legal aid will prevent the individual from presenting their case effectively. To answer that question, we look at the same core factors under Section 4.3 of LASPO and the Lord Chancellor's guidance, namely the importance of the issues at stake, the complexity of the case, and the individual capability. Again, to determine the overreaching question, we weigh all the factors under 4.3, and we do so on a case-by-case basis. Now, just before I move on to the next slide, I'm just going to do a quick recap. To qualify for exceptional case funding immigration matter under controlled work, as I've said before, an individual needs to meet the means test to determine financial eligibility, the merits test to assess the strength and justification of the case, and the ECF test. We also discussed that under under exceptional case funding, the sponsor can apply for legal help, and his name, both names, the ECF1 form and the CW form will be in his name. Regarding control legal representation, we clarified that the applicant for ECF funding must generally be the appellant before the first trial tribunal. The only exception to this is where the sponsor is a separated child. Now, we're just going to move on to the next slide that deals with best practices. Now, when submitting an application, ECF application, it is good practice to provide information and supporting documents on all three heads. That's the means test, merits test, and ECF criteria, and briefly explain how each of them is satisfied. This is especially important because providers do not have delegated functions for ECF work. So the legal aid agency must carry out the full assessment. That means, for example, that ECF team is responsible for assessing the means, merits, and ECF criteria. Now, just to clarify a few things to help streamline applications, you generally don't need to explain how Article 8 is engaged or refer to case law. We're already familiar with the legal framework. For legal help under Regulation 32, you also don't need to explain how the sufficient benefit test is met. It's usually clear from the facts. Now, when you are preparing an application for ECF, it is good practice to include a summary or timeline of event. This helps us quickly understand the background and progression of the case. In any event, if you're happy that the Home Office version of the facts, you don't need to repeat and just refer to them. It is also important to outline the legal issues and explain in bullet point, if helpful, why the case qualifies for exceptional case funding. It is good practice to keep it clear and focused. This helps us assess the application efficiently. And just a quick reminder that all of this is explained in the ECF providers pack. Now I'm going to move on now to the next slide. This next slide is going to be dealing with ECF criteria. I'm going to focus more on the best practices when addressing the ECF criteria. So continue with the best practices. When submitting an ECF application, it's essential you always address the ECF criteria. Make sure you explain why you believe the ECF criteria are met, focusing on the individual specific circumstances. Try to avoid generalized statement. Instead, link your explanation to the overreaching question. To help us assess that, we're looking at things like what type of application is being submitted. Is the process straightforward or complex? Can the applicant understand and engage with the process? Will they be able to submit the application or present themselves at the first right tribunal? So we are consistently assessing complexity in line with capability. So please don't assume we know the matter is complex. You need to tell us. If we don't have the information, we can't assume it. Now, if the information and documents you provide clearly shows that the matter is complex, we won't need to ask for more. But if the application is thin on facts or doesn't address the ECF criteria, we'll have no choice but to ask for more generalized questions. And just to be clear, under Regulation 23.6 of the Civil Legal Procedure Regulation 2012, providers must supply any additional information or documents requested by the director to make a decision. I have to say that in practice, we often have to ask for further information a lot. For example, over the last 5 years, we have asked for further information in 35% of all ECF immigration applications. And that is just initial requests. For family reunion cases, around 31%. Common issues include missing home office decisions, unsigned forms, missing dates of birth for children, no explanation of how the ECF criteria or merit criteria are met. And just a final point on this, while we are waiting for further information, the relevant time frame is placed on hold. So it is really important that you respond as quickly as possible to our request for further information. Please know that when we ask for further information, we're not being difficult. We're simply fulfilling our role under the legislation. I'm now going to move on to the next slide that deals with best practices in respect of assessing merits for controlled legal representation before the first right tribunal. Now, when you are assessing merits for controlled legal representation, there are a few best practice points to keep in mind when submitting an application. First, make sure you complete all 4 sections on page 6 of the CW2 form. This is where you set out the merits of the case. You should briefly explain how the merits tests are met, and in particular, tell us what the process of success are. For question 3, use the proper classification: very good, moderate, borderline, marginal, unclear. We have had applications where prospects were described simply as reasonable or left blank. That is not a recognized category, so please stick to the classifications. Give us brief reasons with reference to your case, explaining how the test is met. For example, what are the key strengths of the appeal? Also, provide a copy of the Home Office decision under appeal, and if available, your grounds of appeal or skeleton arguments. These documents help us understand the legal and factual basis of the case. I'm now going to move on to the next slide that deals with how to handle matters we consider urgent. Please note the following information. Emergency representation is not available. There is no authority to use delegated function under exceptional case funding. What I'm going to just concentrate on here is that, If you want an application to be treated as urgent, make sure you complete page 5 of the ECF1 form. That is where you provide the details explaining why the case is urgent. If the urgency arises after the application has been submitted, you can still flag it. Just contact our customer service team by phone or send us an email. And when you do send us an email, please make sure to include the word urgent in the subject line of your email, along with a brief note about the reason for urgency. Excuse me. That helps us pick it up and prioritize it quickly. Also know that if your application is accepted as urgent, it will be processed within 10 working days. However, please note that we cannot guarantee that a decision will be made before a scheduled hearing or before the urgent work is required. For more details, please, I refer you to the ECF providers pack. Next slide we're going to be looking at will be deal with handling reviews and backdating. Please, I'll be aware of the following regarding exceptional case funding appeals. The standard appeal provisions do not apply to exceptional cases. Instead, we'll create an internal review process which will be carried out by a different decision maker. You have 14 days to submit written representations. We aim to make decisions within 25 days. All representations must be submitted in writing and via email. Exceptional case funding decisions can be challenged through judicial review, and legal aid is available to do this. As required by the civil procedural rules, a data before action must be sent to the legal aid agency's central legal team. In respect of backdating, as you can see, a determination can be backdated to an earlier date. For more information on this, we refer you to the providers, ECF providers pack. Okay, the next slide I'm going to be looking at now is to look at where we draw the line between controlled work and licensed work. And the reason I'm looking at this is because sometimes we get applications sent to us that is licensed work, but the provider or individual sent it as controlled work. So controlled work ends when an appeal is either dismissed or allowed. It also ends when determination is made regarding the client's eligibility for licensed work. However, post-appeal advice remains part of controlled work. So if after the controlled work is done and you want to give advice, post-appeal advice, you can do that under controlled work. It's onward appeal to the upper tribunal, such as seeking permission from the first trial tribunal, are considered licensed work and cannot be carried out under controlled work. If a matter qualifies as licensed work, the application must be submitted via CCMS. That concludes my session. I will now hand over to Graham, who will guide you through the means assessment for controlled work. Thanks.
Hello, I'm Graham MacDonald. I am the technical lead for controlled work and escape cases at the agency and look after all aspects of controlled work, including training, quality issues, mentoring, operational guidance for casework teams, as well as liaising with internal and external colleagues to assist with anything to do with controlled work and escape cases. That, of course, covers means assessment issues, and that's what we'll look at here in terms of the means assessment for applying for an immigration and asylum exceptional funding matter and how to best approach that and have your application approved at the first time of asking. So we'll look at some of the issues that pertain to exceptional applications. So generally, in respect of those means assessments, it's worth noting that there aren't any special financial assessment rules around the exceptional funding application process in respect of controlled work immigration matters. So with that in mind, you should use the same financial eligibility rules as you would for any standard in-scope matter when checking if the client qualifies financially for legal aid assistance at this level of funding. When you make your application for exceptional funding, the exceptional and complex casework team will be checking the client's financial eligibility as part of that application process. So when you come to make the exceptional funding application, please do obtain all of the client's financial evidence in support of that application and ensure that it is submitted along with your exceptional funding application and all of the merits, legal help form, etc. All of that information. If you send that all in one bundle, as it were, that will give the exceptional and complex casework team everything they need to consider the application, and they won't need to get back to you with a further information request. So in terms of that documentary evidence that you need to obtain and include with the application, first things first, if you make sure you're using the correct application form and complete the means assessment before submitting your application for exceptional funding. So for legal help, that would be the CW1 form. And if you ensure that all of the relevant questions are answered, the form will instruct you through the question process. If you need to leave any questions out, the form lets you know. But generally speaking, in respect of the income and capital aspect, just as it would be with an in-scope application, if you answer all of the questions, that will ensure it gives us all of the information that we need to carry out the financial eligibility assessment without the need to request further information from you. So after you've completed the financial eligibility form, include any necessary evidence of income, allowable expenses, and any capital assets if that is needed with the application. There is a page at the end of the CW1 form, which is a checklist for all of the relevant means assessment evidence, and that's quite useful to work through and tick those evidential items off as you work your way through the evidence. And as the slide says, if you don't include the relevant financial evidence, it can delay the decision-making process for granting exceptional funding, as financial eligibility must be confirmed before we can consider the merits aspect of the claim and whether the exceptionality criteria is met. So the means assessment is the first port of call when considering the application. So it's very important that all of that information and evidence is there in order for the application to be considered and processed. Once financial eligibility is established and exceptional funding is granted, naturally, you are okay to begin working on the matter, incurring costs. And if the client has a change in financial situation during the period which exceptional funding is in place, as the slide says, a reassessment of the client's finances will be necessary. Unlike in-scope matters, where at controlled work you would complete this assessment yourself on the legal help file, you can report the change in circumstances to the exceptional and complex casework team, who will then reassess the client's finances and confirm whether exceptional funding can continue. So in order to do that, again, if you complete the relevant means assessment form, so you can just use the means assessment section from the controlled work form, and again provide the relevant up-to-date financial evidence in support of the reassessment. Moving on to slide 26. So what are those evidential requirements? And as I said, there are no special exceptional funding requirements, so they are as they are with any standard application for funding. So if the client is an employee and is currently employed during the computation period, So that is 1 month leading up to the date of application for legal aid funding. You would include wage slips from that computation period with your application for funding. Please note, bank statements showing wage payments are not acceptable. This is due to the fact that the figure showing for a wage payment on a bank statement is, of course, the net payment that an individual receives after all deductions. And given we are only able to make allowances for certain deductions, we can't allow for things that may impact that net figure. So things like pension contributions, student loan repayments, union fees, cycle to work schemes, etc. There's lots of various deductions at source that we can't make allowances for. So the net figure showing on the client's bank statement is not sufficient. So hence why we need the wage slip is due to the fact we require the client's gross wage figure for the month in order to determine eligibility. That is, of course, we need to first establish the gross income test is met. And then if the client is below the gross income of 2,657 per month, we can go on to calculate the disposable income based upon the gross wage. If the client is paid on a weekly basis, then you don't need to include all of the weekly pay slips from the relevant computation period, but do try to include as many as possible, as many as the client can provide. Naturally, if the client is paid once a month, then you just need that one pay slip from that month. And if the client is paid fortnightly, chances are there'll be 2 wage slips from that month. Remember to transfer the figure where you do have weekly payments or fortnightly payments into the calendar monthly figure. So if the client is paid weekly and you only have 1 wage slip from the computation period, you can times that weekly pay slip by 52 to get the annual figure, and then divide by 12 to get the calendar monthly figure. If the client has a partner who's also employed, then wage slips for the client's partner will be required alongside evidence of the partner's finances within the wider application. In addition to any wages that the client receives, if they're in addition to any state benefits, again, evidence of those payments should be included with the application for exceptional funding. In terms of acceptable evidence, the standard rules for controlled work means assessments will apply. So if you have a copy of the client's benefit award letter or letters dated within 6 months of the date of application for exceptional funding, that's fine. Alternatively, if the client has bank statements showing those benefit payments within the computation period, then that is absolutely fine. And as the slide says, that's unlike wage slips, as the state benefit figure appearing on the bank statement will be the gross amount rather than the net amount. Hence why we can use the figure on the bank statement. For clients in receipt of universal credit who have an online account for their payments, a screenshot of that online account is absolutely fine for our purposes, but it must clearly show the client's name, the name of the benefit, i.e. the universal credit, and the dates of payment of universal credit to be received within the computation period. So sometimes you might need to take a couple of screenshots to capture all of that information, depending on the device that the client displays the information on. So something to bear in mind if taking a screenshot from the client's online account. For clients in receipt of asylum support, which they may be, given we're looking at applications for exceptional funding within the immigration and asylum category, in a similar fashion to the client state benefits. If a client is in receipt of asylum support at the time of application, please provide evidence of the award letter. And again, it has to be dated within the last 6 months. And of course, the 6 months is within the signature date on the application form for exceptional funding. If the client's asylum support award letter is older than 6 months, which it may well be, depending on the intervening time between the award and the date of application for funding, and the migrant help will not have necessarily issued a further letter to the client, so it may well be that the letter is older than 6 months. If that's the case, please obtain confirmation from migrant help about the current asylum support payments at the time of application. If migrant help speak to you via the web chat feature, then that is absolutely fine to show a screenshot of that web chat confirming that the client is still in receipt of asylum support. That's no problem at all. On the other hand, if the client has not yet received asylum support and has an application pending, please don't work on the basis that the client is in receipt of asylum support. Instead, confirm the position in the application form and complete a full means assessment based on the client's current situation at the date of application, and how they are meeting their day-to-day living costs. So linked to this, if you have a client who's in receipt of financial support, regardless of their asylum support or other immigration status, this would apply to all clients. If you have a client who is currently receiving financial support, then this should be factored into your assessment of financial eligibility. So this financial support, as slide 29 tells us, can come from many sources, usually family, friends, or charitable sources. You can confirm this in the application, detailing the nature and extent of this support. And it's this phrase, nature and extent, that is the key aspect within our controlled work guidance. So where the nature and extent of this support simply consists of subsistence support only, so food and accommodation, please just confirm this within the application. An estimate of the monetary value of this support is not required. On the other hand, if the financial support does include cash payments to the client of any value whatsoever, please do include the amount and frequency of those payments as a source of income within the assessment. Even if it's just £10–15 a week to, help with sundries, bus fares, etc. If you just clearly the client will likely be eligible, but it just allows us to calculate that the client sits below the 733 disposable income limit. So when monetary payments are made, please do include the value and the frequency of those within the assessment. But as I say, subsistence support only, food and accommodation only, just needs to be confirmed within the application. In terms of evidencing this financial support, we have 2 ways that you can do that. Either a letter from the individuals providing the client with support at the time of application, confirming the nature and extent, that's absolutely fine. Or we do have a pro forma that those individuals providing the support can complete, and that makes it a bit easier to provide the information and doesn't require that the individual or individuals to draft letters from scratch. In terms of the client's capital evidence on slide 30, when you're making an application for exceptional funding, please make sure to include the value of the client's capital assets in the application form. Do answer the questions. Please don't strike through them. If it's a 0, for any particular type of asset, please do confirm that as a 0, just as you would in a standard application for funding. For controlled work applications for ECF, you don't need to provide any documentary evidence of the client's capital unless perhaps there is a reason to believe they may have hidden their assets or have more capital than the usual limits, such as indicators of a wealthy lifestyle. So, expensive watches, jewelry, etc., that they may be wearing when they come to see you. And also, if you are using bank statements to demonstrate and evidence the client's income situation, it's always prudent just to kind of double check that the bank statements given to demonstrate the income side of things tally with what the client has declared for their capital position. So for instance, if the client has confirmed that their current account has 0 in it when you ask them the question in respect of that from the application form, but you can see from the bank statements provided to show state benefit payments, and you can see that the balance is 5,000 during the computation period, it may be worth investigating and obtaining some more bank statements in that respect. And finally, just remember that for CLR in immigration matters, the capital limit is a reduced value of £3,000. For all of the other immigration and asylum matters, including immigration and legal help, the limit is 8,000. So for immigration legal help, capital limit is 8,000. For immigration CLR, the limit is 3,000. For asylum legal help and asylum CLR, the limit is the standard 8,000. So just for CLR immigration, do remember that the limit is lower than usual for those cases. So they are the main things to take into account in respect of the means assessment, which will help you and help the ECC team be able to deal with the application at the first instance, carry out the means assessment, and then move on to the exceptional test that Frank outlined earlier in the presentation. And I hope that proves useful for future applications.